Hello, and welcome to Marino Bar Review's February 2025 bar exam predictions lecture for the MEE essay portion of the bar exam. My name is Michael Marino. I am the third generation in my family to help students prepare for and pass the bar exam, and I appreciate you taking the time out of your day to listen to this lecture. Your legal, inquisitive mind is probably wondering why you should listen to me in the first place. As I mentioned, I am the third in my family to have done this. My grandfather, back in 1946, founded Marino Bar Review, which was at the time the very first modern day bar review course. He essentially helped invent this entire industry. I apologize for that. Following in his footsteps, my father had his own course. He did that for many years until he eventually sold to Barbary. Of course, I'm sure many of you are familiar with. While at Barbary, he designed and founded their essay writing course. He did that for many years while also teaching at various law schools. Fun fact, my father coined the term IRAC, issue, rule, analysis, conclusion. So it was a lot of fun in my household growing up. And that leads me to me, where I've been running my family business now for about 15 years, while also adjuncting at several law schools. I've really gotten a taste of bar review. I've grown up with the bar exam, and I do these predictions lectures every year, every exam, and I've had a lot of success. I've been asked by a lot of people to do more of these and continue doing them. So as long as people find them helpful, I will continue to do my best to predict what's on the exam. This most recent exam absolutely nailed it. So let's hope I can have some more of that success this time around. Before we get too far in, my sales guy is nudging me saying to give our little sales pitch. So if you don't mind, I'll just say that we offer a full variety of courses and complements to help you study for the exam. Probably the most applicable to many of you now is our bar tutors, Marino Bar Tutors, our bar tutoring program. It's not remedial. It's not like, hey, kid's failing math and I need to get him a math tutor. This is to help you study. I'll speak a little bit off the cuff here for a moment, but to say that having lived bar review, the bar exam, my entire life, I can tell you in all seriousness, bar review is sort of a scam. This whole industry is basically based on a lie that taking a bar review course, simply reviewing the law, is going to get you to pass the exam. In fact, it doesn't help. We did studies at New York Law School. My father was a professor there, and found out that people generally pass the exam in GPA order. If you did well in law school, you're likely to pass the exam. If you didn't do well, you're unlikely to pass the exam. And a bar review course doesn't help increase those chances. So what does? Why does the person running a bar review course tell you that bar review is a scam? Well, the reality is that everything a bar review course does can be found online for free. It can be. Googling all the essays for the past 2 decades are available, and their answers are available online. In fact, some bar review courses are bragging about how AI grades their essays for you. What they're basically telling you is that they're too cheap to hire individual graders. You can go to AI. You can write an essay and enter it into AI, and it'll give you your grade score and feedback. So what are you paying for? Well, that's where we step in. That's where we took a look at the industry and said, this is not right. What they're doing is not right, which is why every one of our courses includes our personal bar instructors, our bar tutors, to help you not just review the law, get it, bar review, but not just review the law, but understand how to apply it and score points, because ultimately it's an exam of scoring points. If you meet the threshold, congratulations, you're an attorney. If you do not, so sad, too bad type of thing. And that's what we do here. We help you score points. So marinobarreview.com, marinobartutors.com. It's not too late to have a few hours with somebody to really help you review maybe some of the stuff I'm going through today. If you're unsuccessful on the exam, I do apologize. Send us your score report. You can send it. There's no obligation to purchase anything. marinobarreview.com. Send us your score report. We'll review it with you, tell you what went wrong and how to approach it better the next time. And if you are successful, we do offer continuing legal education as well, especially if you're in a state like New York that requires live CLE for newly admitted attorneys. We're the largest provider in the country for Bridge the Gap lectures. So marinolegalcle.com as well. I think I nailed the sales pitch. So let's get to the fun fun? Let's get to the fun part, I guess, or the meat of why we're here today. What is likely to appear on the bar exam and how it will appear? So let's start with con law. Con law had not been tested from October of 2020. That is that COVID year, if you remember, through July of 2024. It was a 4-year break. But it did appear in July of 2024, and it is incredibly likely to appear again, this time, probably the time after that and the time after that as well. What do they like to test? The Dormant Commerce Clause, sovereign immunity, the idea of state versus federal law interaction, the interplay between the two. Understand the Congress's is right to regulate commerce, what they're allowed to do, the taxation aspect of it. One type of question they ask a lot is a state will create a law giving favor to on the railway leading between states A, B, and C. State B will say state B businesses have priority over this, and now state business in state C who sells in state A is going to sue state B, the middleman, if you get what I'm saying. An essay like that could be asked, absolutely could be asked. Understanding the interplay, what the rules are for that is important. Also in con law, the First Amendment, speech and religion, the idea of a public forum, the levels of scrutiny that go with that. When I say public forum, there was just an essay not that long ago where they banned protests within 500 feet of a school or a courthouse or something like that. Is that constitutional? First Amendment is obviously the biggest one within con law, but just understanding these interplay between these will be very important. And then finally, Equal Protection Clause, that 14th Amendment, strict, intermediate, rational basis review. Understand as best you can when each is applicable, but I'm here to say don't stress too much if your brain just can't comprehend or you can't recall in the moment. As long as you understand that, hey, this requires a level of scrutiny, take your best guess as to what it is and take your best guess as to what the standard is. People are always like, is it necessary to a proper means or is it maybe? I don't. Do your best. As long as you're identifying it, you're showing that you do are spotting the issue, you're going to score points. But pay attention to this stuff. If you need to study it again, study it again. This is likely to be tested. A great example I give that comes from California, which is not a UBE state, so it could be used in the ME, is a case where there's a student in a high school. The high school passes a law that says in order to curb gang violence or bullying or something like that, we're no longer allowed to wear the color green because that's what all the gang members wear. A student who's the valedictorian of high school, wears green one day, gets suspended, and now is suing over this, saying it violates her First Amendment rights. Understand that's the type of question you could see. It doesn't necessarily have to be a student at a school. It could be an employee at a public, a government building. And by the way, in that case that I'm mentioning in the question, what ended up happening was the student not only graduated high school, but ended up graduating college by the time the court heard the case. So now the question is this even ripe? Is it moot? This is what you're going to need to pay attention to. You're going to need to explain as best you can the law here and how it works. So that's what's likely to be tested in con law. What's unlikely, any of the recent Supreme Court cases, the Chevron, affirmative action, presidential immunity, all these are too soon. These essays have been in the works for a long time. It's unlikely that you're going to see this. However, I've given that same speech of what's unlikely to appear before. Previously, I included Roe v. Wade and the overturning of the Lemon test. But maybe now it is relevant. Maybe now you could see something of this nature. So don't just dismiss Roe v. Wade and the Lemon test elimination offhand the way you may have previously. Let's move on to crim law. Or really, when I talk about crim law, we'll talk about crim law, crim pro, and evidence sort of all in one, back to back to back. I don't think you're likely to see 3 essays, one for each. I think likely that there's going to be a combo of these 3 in some fashion on the essay. So how will you test to see it? So crim law, last tested February of 2022, so a couple years ago now. When you see crim law, the big ones are homicide and the degrees of murder. Understand felony murder, an accidental death, the idea of intent when it comes to to a murder, the idea of I'm aiming it at one person and I shoot the person behind them. What is my liability there? Criminal liability. Accomplice liability and conspiracy, not just what constitutes a conspiracy, but how does one withdraw from a conspiracy? Does the person withdraw completely? What steps need to happen in order to do that? This is very fact-based, right? It's taking a substantial step to withdraw. So you're going to have to really pay attention to the facts, and it's going to lead you to this conclusion, whatever conclusion you're going to make. And then finally, affirmative defenses and duress, insanity, the burden of proof switching. This hasn't been tested in a while. I think it's really ripe for testing. And I think that you could actually see all of these combined into one fact pattern, right? A very common one you get is a couple people decide that they're going to rob a liquor store. They say, hey, we're not going to, no violence at all. We're just going to come in and we're going to say, we're going to rob this place. Sure enough, on the way there, one of the people says, I don't want to rob anymore. I don't want to do this, but they still go along with it anyway. And what happens? Someone pulls out a gun. Maybe a police officer walks in also, and the police officer kills one of the co-conspirators. Maybe the gun goes off and the clerk dies as well. And now the person who's tried to withdraw from the whole thing is going to be charged with murder. There's a lot to talk about there. Maybe he will even try and say that it was under duress. At some point, the guy took out a gun and said, you can't withdraw from the conspiracy or whatever. Pay attention to these facts. Know these rules. It's going to be tested most likely. Crim, though, is often tested with Crim Pro. So what do you need to know for Crim Pro? Well, the Fourth, Fifth, and Sixth Amendments. Fifth Amendment, Miranda, self-incrimination. Someone's going to make a confession. Can it come in or not? So understand that. You may see it actually combined in a way with the Sixth Amendment. When does the right to counsel attach, as well as with grand jury proceedings? But understand that right to counsel. Someone may be stopped on the street and questioned. Maybe they're brought into the police station, but they're not arrested yet, and then they're finally arrested. 3 steps along the way. At what point does that right to counsel from the Sixth Amendment attach? Know that. Pay attention to that. Finally, the Fourth Amendment, search and seizure, warrant exceptions. You're always going to see it in a funny way. They recently asked a guy had a suspicious bag. He got out of his car, had a suspicious bag, and the police officer stopped and frisked him, found drugs, and then decided to open up the car without a warrant to search the car and found more drugs. Can the search of the car, is that legal? How about another example where a pizza delivery guy is delivering a pizza to a house at the same time the police come and execute a warrant on the house. And now the police guy, the pizza guy, is found to have drugs on him, right? Is that plain view? Is that a warrant exception? These are the questions you're going to be asked. They're never going to be straightforward and easy necessarily. So really pay attention to all of this. And by the way, it could be that the same piece of evidence, the same statement, the same search could be tested under the Fourth, Fifth, and Sixth Amendments, right? A confession, maybe under the Fifth Amendment, it's fine because Miranda was given, but maybe the original right to counsel had attached before they had done the Miranda. So pay attention to the interplay between that. That's Crim Pro. I don't know if it's going to be tested on its own. I think maybe it could be tested with Crim Law. That leads me to evidence. Start with hearsay. Not just hearsay, obviously, but the major exceptions to hearsay, right? And even non-hearsay. If you are a Marino student, there's a chart in your materials, in your Marino study notes that have hearsay, non-hearsay exceptions. Memorize that. I mean, truly just memorize it. Sit and do what you got to do to know the differences between all of them. I know that it can be confusing. I know that business record can be different than a medical record or a lawyer's records, right? Keep in mind these differences, but do your best with them. Identify it on the exam. If you get it wrong, at least you're identifying the issue correctly. But I think more likely than hearsay, though hearsay is certainly going to appear on the MBE, so just know it, is character evidence, specifically prior bad acts, and using something like that for impeachment purposes. A good example from a recent exam is someone's being arrested for robbery 5 years ago. They were arrested for robbing a liquor store. Now they want to bring in that conviction or the arrest maybe So know when and for what purposes can a prior bad act be used as character evidence. And the last thing I'll say is relevance. Simply stating, and this sounds silly, it's like writing on the SATs. They say you put your name and you get 400 points automatically. The idea of relevance, just simply saying that when you see an evidence question, that all evidence must be relevant in the first place to be admissible. That's free points. That's free points on the exam. Make sure you just remember to say that. So that was the interplay between crim law, crim pro, and evidence. Let's move on to something that I would bet money, if I could bet a lot of money. I would bet a lot of money that civil procedure, and I know you don't want to hear me say that. That's guaranteed, I think, to appear on this exam. It's dry, it's boring. I write a book on Civ Pro every year for Westlaw, and I can tell you it's boring even to me. But you need to know it. So what do you need to know? Obviously, subject matter and personal jurisdiction. When and how does a court have jurisdiction to hear a matter? Is the person in the right court? Federal and state court issues with that. Along also with the same concept as motion practice, the idea of joinder, permissive versus mandatory joinder. When do you need to know all of that? And then also change of venue, the idea of forum nonconvenience, both in terms of filing and then also for a witness when it comes to Civ Pro. Finally, the thing that I think has not been tested for a while that seems likely to appear this time, so I really want you to pay extra attention to it if you just sort of glanced over, is the concept of res judicata and collateral estoppel. I know it sounds pretty basic, but I think it's highly likely to be tested. I really cannot emphasize that enough. The idea of claim and issue preclusion. An example that has come up on the exam previously is there's an accident between two cars. Driver A sues driver B for negligence. The court finds that both parties were negligent. Then years later, party B develops injuries that were not readily apparent and now is suing years later, suing A for the same accident. Has that been... Is that allowed? Can the fact that they were both found negligent in the first place, does that preclude him from bringing it or from recovering? These are the types of issues that I would say if they're going to test Civ Pro, it's going to be like that. So really make sure you understand these concepts and you can explain it, not just know it, but explain it in terms of an essay to score points. Moving on, torts, likely to appear. Last tested July of 2023. It's ripe for testing. They usually don't go this long without testing torts. Oftentimes, it goes torts, contracts. But they haven't tested torts in a while, so let's make sure you know torts. Negligence. I think we'd all would love just a basic negligence analysis, but I think really if you see negligence, it's going to be the idea of vicarious liability or strict liability. As a separate sort of issue, understanding the difference between negligence and strict liability. The idea of vicarious liability is also often tested with agency, which I'll get to in a moment, but maybe more likely than simply negligence is products liability. Or, as I mentioned just briefly, the idea of the interplay between strict liability and negligence, understanding the difference between the two. Oftentimes, a way to really miss out on points is not really appreciating the difference between the two. I mentioned agency and partnership. That's the next thing I want to talk about. It's often tested with torts and contracts, right? So when it comes with torts, right, you have vicarious liability, respondeat superior. How is that tested? The two most common ways are someone takes a detour at work. Maybe a plumber stops to get a cup of coffee. Or maybe someone else stops to pick up their dry cleaning. Is it within the course of business? You're going to have to argue that. You're going to have to know the rules and the law surrounding that sort of detour. The other side of that is the idea of an intentional tort. The most common example is a bouncer at a bar punches somebody. Is the bar owner going to be liable? These are common exceptions, and maybe you can think of some uncommon ones that could come up. But this is something that is likely to be tested. Similar vein is actual versus apparent authority. Who's going to be liable for an agent's actions? The way that this is tested most frequently, or most cleverly, I should say, maybe not most frequently, but most cleverly, the way that I've seen it tested that I think a lot of people don't always pick up on is an example from an actual bar exam is there was a party, a law firm had a party. At the party, for these are the prospective clients who are going to show up, a partner introduces a prospective client to an associate. The partner leaves, the associate hands the person a business card, and where it says associate, it's crossed out, and inside they write partner, right? And then they enter into a contract, the client and the associate, and now the question is the partnership going to be liable for that contract that was signed because they did not have authority, but there was the appearance of authority, right? Apparent authority versus actual authority. This is how it's tested. So really pay attention to the subtleties of the laws and rules. It's something easy that most people just don't want to spend much time on because agency is a short, sort of not as meaty or scary as CivPro, but it's tested quite frequently with torts and contracts. Lastly, partnership liability, debts and obligations, new versus old partners when a new partner comes in, who can share. That's all pretty basic, but just understand it. These things come up quite often, especially in torts and contracts. But I have seen straight up agency and partnership essays, and they come at you the way I just mentioned. Lastly, the thing I want to talk about as very likely to appear is decedents' estates, wills and trusts, likely to appear. It's tested every other exam, and it was not tested on the last exam. And really, the pattern goes back several years. So if you believe in patterns, then it's going to be on this exam. Will execution, codicils, the validity, incorporation by reference, understand the rule, the formation of a will and a proper codicil, and the effect it has if a codicil removes a gift from the will, and what happens if the will is validly executed but the codicil is not. Next, the idea of mental capacity, insane delusions. Capacity is important, right? If you don't have the capacity to create the will, then you're obviously, the will is not valid. But this is something that has not been tested, but has come up frequently in cases in the real world. So the idea of mental capacity, insane delusions, and undue influence, these types of challenges, almost certainly, if you see a wills question, I think you could get. So really go back over that one last time. So that's my predictions. I'll give you some extra final study tips real quick, just because I can't help myself. I want to see everybody pass the exam. Prioritize the subjects I mentioned, but don't ignore the other ones. This is not the be-all and end-all of what is likely to be tested, but how should you be studying this stuff? The best advice I can give at this point, now that your lectures are over and you're sitting with your study notes, is you not need to see the law in action, and specifically on the bar exam. I mentioned at the very beginning of the video that all of these essays are available for free online. Go to the bar examiner's website and just start going chronologically back in time, looking at the essays and then the model student answers. Read the essay, issue spot. If you have the time to time yourself and write it out, do it. But if you don't, and you may not at this point, I can't urge you enough to make sure you're reading through these things and getting the idea of how the law is tested. These bar examiners are clever. They are. But they're not beautiful at making prose, right? They don't have come up with new fact patterns and new situations. They retest the same basic ideas over and over again, just coming at it from a different angle. So really go through these essays. Remember IRAC. I know it's my father's thing, but the best, highest scoring exams are the ones that just simply state the rules and the analysis correctly and don't have to go into some long-winded prose and exposition over the law. For Marino students, if you're in our course and you feel like you want to add more hours, now will be the time to do it. And really don't hesitate to tell your tutor what you feel is missing. Show them your work. They will grade it for you. For non-Marino students, you can still sign up for a tutor. This is not remedial. I really need to encourage that. This is an investment into your future, and one that I wholeheartedly believe in, that I used myself when studying for the exam, which got me through it. And then again, if you're unsuccessful, it's not the end of the world. I know a lot of incredibly successful people who failed the exam. I know you don't want to hear, oh, well, Hillary Clinton failed it. I know you don't want to hear that, but the reality is, send us your score report. We'll give you that score evaluation. We'll help you figure it out the next time, and you can put this thing behind you. If you have questions, if there's anything that I can do to help you out, I just want to see you succeed. I truly do. So I hope you found this worthwhile. Get back to studying. Good luck, and I will see you in court someday. Thank you.